Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1400 et al. National Treasury Employees Union petitioner versus Federal Labor Relations Authority. Ms. Bailey for the petitioners, Ms. Osborne for the respondent, Mr. Busa for the interveners.
Thank you. Let's start. Mr. Bailey, Ms. Bailey, sorry, excuse me.
Thank you, Your Honor. Good morning, and may it please the court. My name is Catherine Bailey. I'm with the National Treasury Employees Union, and I'm here today on behalf of the three petitioner unions. In the 2-to-1 decision below, the Federal Labor Relations Authority stated for the first time that agencies can enforce new regulations on contracts extended by continuance provisions. These provisions, bargained for by the parties, keep agreements in place pending negotiation of a new contract. The court should set the decision aside for 3 separate reasons. First, the decision conflicts with the plain language of Section 7114C of the Federal Labor Relations Statute, which governs agency head review. Second, the decision conflicts with the plain language of Section 7116A7, which prohibits the implementation of new regulations while an existing agreement is still in effect. Each of these statutory conflicts alone requires the court to set the decision aside. Third, and finally, it was arbitrary and capricious for the authority to issue a policy statement at all, for the reasons set forth in our briefs. Starting with my first point, Section 7114C. The statute provides for agency head review upon the execution of a new agreement. An agreement extended by a continuance provision.
If I can ask you a question. So your argument is that this opinion here is invalid as a matter of law because it conflicts with the statute. And so if that's the case, and if we were to rule in your favor, does that mean that the FLRA's longstanding rule on rollover contracts would also be invalid and inconsistent with the statute?
No, Your Honor.
Is there any way to distinguish those as a legal matter?
Yes, our position is consistent with Army, the longstanding FLRA decision, and that's because of the differences between rollover provisions on the one hand and continuance provisions on the other hand. Under a rollover provision, the contract is automatically renewed, and under a continuance provision, the contract is extended only until renegotiations are complete for the next successor agreement.
Why is that a difference that matters as a matter of law?
Well, in the continuance provision contract, looking at the statute, in a rollover situation, the contract is essentially being, when it's renewed, it is executed for a new term. And nothing is left to be done for the new term to go into effect. That's why you could say there's an execution in that scenario.
Isn't that true of a continuance as well, though? Because once a party asks for renegotiation, the contract extends. For an indefinite period, but it still extends past the end date.
I think what's important there is that it's the same agreement as the parties have bargained for. They've bargained for it to continue only until the new agreement is in effect. And so
a rollover clause also has the same agreement remains in effect, just for a new term.
While the language may be similar, I think it's important to look at what's going on in a broader context. And in a continuance scenario, the parties are renegotiating their agreement. And so they are working on the successor agreement, and the continuance period lasts only until that successor agreement is in place.
Sure. In one situation, the extended term is typically for a fixed duration. In the other, the extended term is for an indefinite amount pending negotiations. But the question in both contexts, which may be a little bit metaphysical, but the question is whether the parties are still under the original agreement once the term is extended.
Yes, and the parties have bargained in a continuance provision scenario to be, in fact, under the same agreement. That's what they anticipated when they included the continuance provision in their contract initially.
Why aren't they under the same agreement in the rollover context when the agreement extends by operation of the original contract?
It goes to the difference between renewal on the one hand and extension on the other hand. And a renewal sets up a new term, which is treated as a new agreement.
Has any court, this court or any other court, upheld the FLRA's interpretation of rollover provisions in the Army case?
Not to my knowledge, Your Honor.
So that's, again, that's longstanding FLRA, but it's not yet been reviewed by a court. You don't challenge the consistency of the rollover rule with the statute.
That's correct, Your Honor. We are not asking the court to overrule Army. We are explaining why this scenario is different than Army, than rollover provisions.
So for these purposes, you take as given that the rollover provision, the body of law starting with Army on rollover provisions is lawful, permissible.
Yes, that's correct for the purposes of this argument here today.
Another thing I'm curious about is, the statute's been in effect a long time. And I think these continuance provisions are nothing new. There's nothing novel about them. But neither brief tells me what the practice was before this general rule came into effect. I'm assuming the practice was that there was no agency head review for continuance provisions. I mean, the FLRA cites cases of inconsistency, but I think those are all rollover cases. So what was going on? Were there cases, were they also inconsistent with continuances, or was there a consistent practice beforehand, or nobody knows?
My understanding, Your Honor, is that when a agreement included a continuance provision, all of the parties would treat that agreement as continuing, consistent with our arguments here. And it's important to note that continuance provisions are completely optional. So some agreements, the parties bargain to include them, and other agreements, they don't. So
these have been included in contracts. I get that not every contract has them, but they've been included in contracts for a long time, or are they kind of a novelty?
For a long time, as far as I know, Your Honor, yes.
Since sort of the beginning of the statute?
Yes.
And there were no FLRA decisions addressing this, what the nature of a continuance provision was prior to this general rule?
Your Honor, I don't know of any FLRA decisions addressing continuance provisions specifically.
So I guess that means you're also not aware of there being any cases where the FLRA or an agency tried to enforce new rules and regulations during a continuance period and a party challenged that.
Yes, Your Honor. To our knowledge, all of the decisions related to 7116A7 and new regulations are about rollover provisions, not continuance provisions.
What does the statute tell us about whether the agreement is the old one or a new one under these circumstances? And I'll give you a hint. I think the answer is next to nothing.
I think that's mostly true, Your Honor. I think you have to incorporate this continuance provisions themselves and what you can glean about the party's contractual intent consistent with the statutory scheme.
If the statute says very little, why wouldn't that be a strong case for deferring to the agency?
Well, first, I think all of the tools of statutory interpretation are available when to determine first whether the statute is ambiguous or not. Even if the court doesn't agree with us on Chevron step 1, the authority's interpretation is unreasonable, and the court doesn't defer, to unreasonable interpretations.
But you just conceded, I thought, that the statute is silent on this question. So how do we then get that the statute unambiguously resolves the question in your favor, and in any event, the agency's view is unreasonable?
I didn't mean to say that the statute is ambiguous or that there's a gap to fill. I think when you look at the tools of statutory interpretation, you can look at the plain language of the provisions, which state that in 7114C, you need an execution in order to have agency head review. And under 7116A7, if an existing agreement is still in effect, which it is here, then new regulations that are in conflict cannot be unilaterally enforced.
You need an execution. That's a textual clue, no doubt, but executions just happen when a contract is finalized, correct? So we're just back to the question of when a party does what's necessary to extend the term in the extension clause, which is register the objection and trigger the renegotiation. Does that act create a new contract, in which case there is an execution, or is all this happening under the old contract?
It's
So-
all excuse me.
Well, sorry. So we're just back to where I started.
Well, it's all happening under the old contract, but you can use the meaning of execution, including under the FLRA's case law, to understand why that is. Under the FLRA's case law, including the old Army case, an execution occurs when there's nothing left to be done for a new agreement. And here, in a continuance provision context, the parties are renegotiating the successor agreement.
Ms. Bailey, if we were to assume that the statute is ambiguous, what are your arguments for why this is an unreasonable interpretation?
The interpretation, sorry, I didn't mean to speak over you. The interpretation is unreasonable because the authority relies on the policy rationale that contracts require fixed end dates, presumably a calendar date is what I understand them to be saying. When a continuance provision goes into effect, it's undisputed that that continuance period itself does not have a concrete date. The date that it ends is when the parties execute the successor. So there's the policy rationale is inconsistent, and the authority has not addressed that aspect of their reasoning. I think I'm almost to my rebuttal time. I'm not sure if the court has any other questions at this moment.
My colleagues have any more questions? Okay, thank you very much. We'll hear from Ms. Osborne now.
Thank you, Your Honors. May it please the court. My name is Rebecca Osborne, and together with Noah Peters, I represent the Federal Labor Relations Authority in this matter. The authority reasonably issued the policy statement because it was necessary to clarify how can agency head review and the enforcement of government-wide regulations occur within the context of an agreement with a continuation period. And it was necessary to clarify that because the statute is silent on these two issues. And the issue—
What had been the practice before this?
With respect to continuance provisions?
Continuance provisions only.
Only. Your Honor, the U.S. Department of Agriculture actually had requested this policy statement because—
No, that's not my question. No, because the things that are cited in there are rollover. There wasn't inconsistency, as I saw it on this issue. It was on rollover issues.
But what they were saying was that arbitrators were relying on those cases to make different decisions with respect to continuance provisions. And that's why USDA
Were
was
they able to
asking-
cite an arbitrator decision involving a continuance clause that was,
They did not, Your Honor.
they didn't cite any arbitrator decisions that were inconsistent. Are you aware of any arbitrator decisions that are inconsistent?
I am not, Your Honor.
So as far as you know, the consistent practice for decades before this general rule was that there was no agency head review when a continuance provision kicked in.
Your Honor, I have no evidence either way on that.
The FLRA was completely ignorant of how that happened.
Excuse me?
The FLRA was completely ignorant of how continuance provisions were being applied and when agency head review kicked in.
Your Honor, we were told by the agencies that that arbitrators were interpreting this in different ways.
More than one agency?
I definitely know that the U.S. Department of Agriculture said
Right, but
it.
that's when they asked for this general rule. Were you told any time before that?
No, Your Honor.
No one was
This was the
complaining about a
basis
problem
for the
there.
authority's decision.
Okay.
And the authority's decision to issue this rule, though, this policy statement was consistent with the decision that it made with respect to rollover provisions. And the policy goals in both cases are the same. The authority was attempting to balance both the need for parties to be able to rely on the terms of a contract, at the same time ensuring that those terms eventually were brought into conformance with government-wide regulations. And actually, there was a decision, I'm sorry. Yes, Your Honor.
Sorry, did one of you have a question?
No, I was
Can I-
going to mention a subsequent case. I
Okay, then
apologize.
I will, I thought one of my colleagues had a question, so I didn't want to speak over them. So one of the things that the FLRA decision talks about a lot is that, you know, contracts need to have, I think in their word, unambiguous, knowable effective dates and durations.
Mhm.
Does that mean it has to be a calendar date, or can an event be what triggers the end of an effective period?
An event can trigger the end of an effective period.
Okay, so you could have a contract that would say upon, instead of saying on, it ends on March 31st, whatever year, it would say upon X event, this contract,
Yes, Your
change in
Honor.
administration or whatever, this
Yes.
contract. is terminated.
Yes,
Okay.
Your Honor.
All righty. What some of the contracts I've looked at, most of the times these continuance provisions are part of the definition of the duration,
Mhm.
right? It will say it expires on X date, but if someone has asked for negotiations in advance and they are still ongoing,
Mhm.
then it will continue until there's a new collective bargaining agreement.
Yes.
So that sounds like it has a very concrete, knowable, unambiguous termination date when there's a new CBA.
Well, Your Honor, but that interpretation doesn't give any weight to the portion of the agreement that says this will expire on X date and then will
But
continue.
that's what I'm just telling you. You just said that it can expire on a date or on an event. And what I'm telling you is, now we have to do this without any contracts in front of us. That was the FLRA's decision to go this route.
Mhm.
But there's lots of contracts as a matter of public record that show that these continuance provisions are part of the definition of the term of the contract. And so it seems like it's actually giving full effect
Mhm.
to the term provisions in contracts if the continuance provision is part of the termination or duration clauses, right? In fact, it seems if you say that's not, that event is not the termination date, that seems rather rewriting the provision of the original contract. To say that there's a whole new contract. So I'm having trouble grappling here with what the FLRA was thinking.
In the example that you just gave, there are two termination dates. One is the expiration of the contract, and the other one would be the end of the continuance
What
period.
do you mean there's two? There's not two, there's one. It's as if they said it'll be March 31st or upon the conclusion of a collective bargaining agreement, whichever comes later. Is that two termination dates or one?
That would be two termination dates.
That's two termination dates. If they say it's on this date or this event, whichever comes later, is two termination dates? That sounds to me like one termination date in a contract.
But Your Honor, there is an expiration date and then there is the conclusion.
So
of the
parties can't
continuance
contract
period.
for this date. Would you agree that if they said it'll be March 31st,
Mhm.
this or when the agency has when the agency some event happens in the agency, right? So when the agency finalizes a new workplace policy,
Mhm.
you would say that's two termination dates with that or in there?
Yes, yes.
Is there any principle of contract interpretation that you can point to that says that's how we would read a provision that said it terminates on this or this, whichever comes later, as two terminations, one termination and then a second termination? Any
Well,
contract case that's ever held that?
Your Honor, what the authority is attempting to do in this context is to reconcile.
I'm not asking that. My question is
I
more
understand.
basic about just basic contract law, federal contract law, whatever you want to point to. Is there any case that has said when you have a termination date that says it'll be A or B, whichever comes later, there's actually A is a termination date and B is a termination date? There's two terminations.
If you are talking about the termination date being on an or, as opposed to there is an expiration date and then it will be extended.
I'm sorry.
I'm agreeing with you, Your Honor. I'm saying that if you're talking about or, where there is a termination date.
Well, isn't that exactly what these provisions mean? They say it'll terminate on this date unless contract negotiations are ongoing, at which point it will continue until they're done. It'll be
No,
either
Your
this
Honor,
date or, comma, if there's continuing contract negotiations, comma, when negotiations are done. It's still or.
Well, actually, the or would be the operative term in the example that you just gave. In a lot of these provisions talk about an effective date, and then the period will be extended to another date.
If they had a but instead of an or, they had to send on this date period, but if negotiations are ongoing, it will extend until this time, but would work just as well.
It
As
would
or.
depend upon the language of the specific contract.
So it sounds like it's hard then to figure out whether these continuation provisions actually trigger a whole new contract without knowing what contracts say.
Well, no, Your Honor, what the authority did was issue a general policy statement, and it actually has applied this in a specific case after briefing was done in this matter. So if you look at U.S. Department of Veterans Affairs 72 FLRA 287, which was issued on May 21st, 2021.
Is that cited in your brief?
It
Or
is
anybody's
not.
brief?
It is not cited in the brief because it was issued after briefing was done in this
Okay.
matter.
You didn't do a 28J letter, or do I know that your opponent knows about this case? I haven't, maybe my colleagues do, but I don't know anything about this case.
No, Your Honor, we did not. But in that case, the authority said that a continuance period, there was a contract with a continuance period. Following the start of the continuance period, government-wide regulation had come into effect. The authority said that the agency could not enforce that regulation because it came after the start of the continuance period. And so
Isn't that inconsistent with the policy statement?
no, Your Honor, because if the policy statement says that if a government-wide regulation, it comes into effect before the execution or beginning of the continuance period, then it can be enforced. But if it comes into effect after, it
After
may
the
not
start
be
of the continuance
enforced.
period.
Yes, Your
Can
Honor.
I ask you a question, Ms. Osborne? So
Sure.
most of the briefing treats the two provisions, 7116A7 and 7114 kind of together. And I was just wondering if there is, or if the FLRA has thought that perhaps those two provisions might apply in a different way to continuance contracts. Like, for instance, maybe a continuing contract is not executed, when the continuing period starts, but the original contract is no longer in effect. So maybe there's some space. I mean, maybe you don't get agency head review at the start of a continuing period, but an agency could enforce rules and regulations that had come into effect during the contract's term. I just wonder if there's like any space between the two provisions, or how they could be understood, or if they must be understood in tandem.
I think that the authority considered those two provisions in tandem, whether or not it had to be that way. The standard under Chevron is not whether or not this is the best decision, but rather whether this is a reasonable one. And I think that execution is when nothing further needs to be done to set the terms. And in a continuance period, you are talking about a universe of terms. There is no negotiation concerning the terms during a continuance period. The negotiations are happening as to the successor agreement, not to the contract that is the successor period. And so and as far as in effect, the terms of the successor period would be in effect during that time.
Let me ask you a slight variation on Judge Millett's theme, which is your position is that in the period of extension, the parties are under a new contract. But as a matter of basic contract law, you can't have a contract without agreement.
Mm-hmm.
And the only agreement I can see is the original agreement in the first collective bargaining agreement, because what triggers the extension in the continuance context is the unilateral action of one of the parties, which gives notice and says, we don't like the contract and we want a new one going forward. Mm-hmm. There's no second agreement there. So how can there be a different contract?
Well, again, this is similar to the rollover context where there is a unilateral there.
I'll get there in a second, but just try to help me in the continuance context, which is what's before us.
Yes, well, the terms of the agreement during the continuance period are set, and those terms had been agreed to, and they are also implicitly agreed to going forward when the parties fail to conclude negotiations on a successor agreement by the time that the termination of the initial agreement happens.
I'm sorry, but what's the second agreement? What creates the second agreement? Just the fact that they
have failed to conclude negotiations on a successor agreement.
That sounds to me like the absence of agreement, not a second agreement.
Well, but there has already been an agreement that those terms of the initial agreement will continue until the parties finish the successor agreement. So those terms are already set. And by failing to conclude negotiations, the parties have agreed that they're going to abide by these terms that are predefined until they reach a successor agreement. And that agreement can take place over the course of years. And part of this, go ahead, I'm sorry, Your Honor.
I think I understand. I'm not sure I heard a second agreement, because you said, well, everything was preset, which is right, but it was preset in the original contract.
But we're talking about a new term of the agreement. So there has been, you've passed the express term of the initial agreement. And so we're talking about a new term of the agreement, which is the continuance period.
And then I suppose that loops us back to Judge Millett's point, which is that may just be the later of the two possible expiration dates. So.
It depends upon the terms of the contract, Your Honor. But if
it depends on the terms of the contract, that's not a great answer for you in the context of generalized guidance with no contract provisions before us.
Well, I think, Your Honor, though, that it is a broad principle that can be applied when you are talking about contracts where there is an expiration date, and the decision hinges on there being an expiration date in a contract with a continuance provision that then is extended, and you're talking about a new term of the agreement. The thing is that you have to give meaning to the
Just to be
term
clear, though,
expiration.
you said if the natural reading of the contract language is that the expiration date was A or B, whichever occurs later, this rule wouldn't apply. So it's only in some situation where the fair reading of the contract provision does not have a sort of A or B, whichever comes later reading. You're only talking about that subset of cases with this general rule.
That's correct, Your Honor.
Can I ask you? I'm
yeah.
sorry, are you done?
Go ahead.
Sorry, no, but maybe
ahead.
I missed something earlier. Your position is that this guidance does not apply to the category of contracts that are described by the duration of the first contract is until A or B, whichever is later?
Yes, because there has to be an expiration in a contract in order for a new term of the contract to
I'm sorry, yes. So your guidance does cover?
The guidance covers contracts where there is an express expiration of the agreement.
Where does the guidance cover a contract which says this remains in effect until December 31st, 2021?
And then after is extended.
Unless by June 30, 2021, a party gives notice of a desire to renegotiate, in which case the contract will remain in effect pending negotiations. Does your guidance cover that or not?
Your Honor, I think what the guidance covers is when there is an identifiable expiration date, and then the contract will extend beyond that expiration date.
Why does that matter for your position? I guess I don't understand why that would make any difference, like whether it was an A or B type of expiration clause and then a continuing period began, or it was just a date certain. In either event, there is a term of the contract, and then there is a new continuing period. So I'm not sure why there would be any difference under all the other reasons you stated for your argument.
Yes, Your Honor, we are talking about the term of the agreement, and following the term of the agreement, there would be a agency head review and the enforcement of government-wide regulation.
So in your position, would it matter what brought about the end of the term? I mean, that would just be a particular contract.
It would not matter what brings about the end of the term. There would be an expiration of the term and the beginning of a new term of the agreement.
Doesn't matter which of the A or B causes it, but if the provision is fairly read as A or B, whichever comes later, then only the later date would be the expiration date.
I think, Your Honor, if it sets the term, when you set the term of the initial agreement and then you begin a new term of the agreement.
I don't understand what that means. I'm asking you exactly what that means. If we set the original expiration date, the original term, it expires on date A.
Yes.
Or event B,
Mm-hmm.
whichever comes later.
Mm-hmm.
In that case, it doesn't end. You don't care if it's A or B, but either A or B, whichever is later, is going to be the end of that contract. Nothing new can start until that point.
It would end at the term of the initial contract and then would begin a new.
Is the term of the initial contract in an A or B, whichever comes later, is whichever comes later.
is a new term.
Whichever comes later is not a new term. Whichever comes later is the end of the first contract.
I think, Your Honor, that we're talking about two different terms of the agreement. One is the initial term.
No, I'm giving you exactly what the term of my contract is. I look at a contract and I say what its duration provision means is that it expires on calendar date A or on event B, whichever comes later. That's how the contract is read. That's what the parties intended. That's how the contract is read under basic contract principles for reading contracts.
Mhm.
That's what I'm giving you. I'm just trying to clarify because I thought you reconfirmed that position to Judge Katsas, but now I'm concerned that maybe I misunderstood something. So it's when you have an A or B, whichever comes later, and that's how we know when the contract ends, contract's term ends, it's going to be whichever comes later.
It would depend upon when the expiration date is and how.
I told you the expiration date is whichever comes later. I'm just trying to get you to agree that if the expiration date is whichever comes later, then the expiration date is whichever comes later.
That would be correct, Your Honor.
I mean, that's fine, but I mean, that is going to make your guidance apply to almost nothing. I mean, I've looked at a handful of these agreements, which I don't know for sure, but I assume they're representative. So let's just take one to be concrete. All right, so this is a CDC agreement. It says, it gives the term of the agreement, and then it says if either party gives notice of an intent to terminate or renegotiate, has a time date for that. And then the provision says, if renegotiation of the agreement is in process, but not completed upon the expiration date of this agreement will be extended until the renegotiations have been completed. Does your guidance cover this CDC provision?
Yes, Your Honor, it would, because under the terms of that agreement, you're talking about an expiration date and then an extension of that. So that you're talking about one term of the agreement followed by a second term of the agreement, because it has to give effect to the expiration, the fact that there is an expiration date in that agreement.
And you think that the specific contract provision that I just read you is dispositively different from Judge Millett's hypothetical contract provision of A or B, whichever is later?
Yes, Your Honor, because the terms are different. In the contract that you just talked about, you have an expiration date of that agreement, and then there is a new term when you're talking about an extension beyond that. That is fundamentally different.
It's different words. Is it any different in meaning?
Yes, it is, Your Honor. It is different in meaning.
What evidence do you have that both parties agree when writing a provision like that the contract actually ends and a whole new contract begins? Because they use words like remain in effect or continue in effect. That's the language that I've seen, which sounds very much like the old one keeps going and not a new contract is. So
the same language is used in the context of rollover provision.
We haven't upheld your rollover provision interpretation. So I don't know where that's getting you. We don't have briefing on that here. So I don't know that that adds anything to this dialogue. Although I think, as Judge Katz has pointed out, contract law has long drawn a distinction between evergreen provisions and status quo provisions. So just put that aside and answer me on, it's a matter of plain contract, ordinary contract principles. How it is you can say, when parties say the contract will expire here or upon X event, it will remain in effect until X. So that means an entirely new contract is started.
It means that an entirely new contract is starting because you've had one term of the agreement and then you're going to have another.
That all depends on you reading that provision as it expires X.
Well,
And
it's a
then
matter.
Negotiations are going, we'll start a new contract that begins on X+1. But if those provisions are fairly read, as Judge Katz has indicated, as it will expire on X calendar date, or on, if negotiations are ongoing, on this event, completion of a new CBA, whichever comes later, you lose.
Well, the thing is, Your Honor, that the expiration date and the fact that there is an expiration date in that agreement has to be given meaning. If you ignore the expiration
No,
date,
it doesn't. No, because I think that's the whole question here. You're assuming that the first calendar date is the expiration date. And my question to you is, if the provision is read as instead that the expiration date is A or B, whichever comes later, then you can't say there's one expiration date we have to give effect to. You have to give effect to the contract expiration date, which is A or B, whichever comes later.
in the example,
you have to give effect to that.
but in the example that Judge Katsas gave, we are talking about an expiration date and then an extension afterwards, which indicates a new term of the agreement. And that new term of the agreement could go on for years.
Do you know how?
And there also is the policy consideration.
Sorry, before you get to that, but
eventually-
do you know how? I just haven't been able to find out. This is not the only labor law statute in the federal domain. Do you know whether under the NLRA, which will contract collective bargaining agreements can have these type of continuation provisions, or government contracts, so like military contracts or spending contracts, any of that? Do you know how these is the FLRA's interpretation consistent with, different from, or you have no idea how it's interpreted in those contexts?
Your Honor, I am not certain, and I don't want to give an opinion because I can't think of anything off the top of my head. I apologize.
Do you know if the FLRA's interpretation here is just consistent with general basic contract principles, like our
Your
Contracts 101 from law school?
Yes, Your Honor, but it's also consistent with the statute. And one of the
Can you tell me
purposes
what?
of
Can
the
you
statute.
I asked you about general contract principles. Do you have case that you can cite or a treatise you can cite that tells me that what the FLRA did here is consistent with how contract law is interpreted just generically in the common law?
I can provide you with additional case law on that if the court
Okay,
will.
but you're confident that it's consistent with it. You said it is.
I believe it is.
Sure.
I believe it is consistent, Your Honor.
Okay.
Osborne, I'm wondering a lot of these hypotheticals get to, there could be obviously a range of different types of continuance clauses. And I'm wondering, presumably the FLRA in any particular case, when, an agency tries to enforce rules and regulations during a continuing period, if those are charged as unfair labor practices, those would be each considered the individual facts and circumstances of those contracts.
That is true, Your Honor. In each one of these cases, for enforcement of this policy statement to happen, the case would need to be assessed on the facts of the case.
Thank you.
Any further questions? Okay, thank you. It kept you a long time, Ms. Osborne. Thank you for
Your Honor.
Mr. Busa?
Good morning, and may it please the court, Joe
Did I say
Busa
it
on behalf of the interveners.
Did I say it right? Busa, you said?
You did, Your Honor. Yeah, that's exactly
Okay,
right.
good.
It's pretty rare to get it right, but you nailed it.
Mine's always pronounced
so-
wrong.
Well, I hope I don't do that this morning.
No,
I'm here on behalf of the interveners. As you know, that's the U.S. Department of Agriculture and the Office of Personnel Management. I think it would be most fruitful to step right in on what's occupied most of the discussion this morning, and that is the question of the relevance of the specific contract language to the authority's determination here. And I just want to emphasize that the common law of contract really has nothing to say about the statutory effect of the beginning of a new term after the prior end date of the prior term was reached. The parties can set
So let's start with background contract law principles, because I didn't researched this extensively, but I did find Contract Law 101 provisions suggesting that renewal and extension are both terms of art in contract law. And the difference between them is precisely that an extension extends the original contract and a renewal creates a new contract.
I believe that's the normal usage of those terms in the common law of contract, Your Honor. However, here what we're dealing with is a special statutory understanding of that term. We're dealing with the effect of, I'm sorry.
Why is that? Because you're right that the reason everyone cares about this question, whether we are in a situation like this, whether we're operating under the first contract or under a second, a new one, is because two legal consequences specified in the statute flow from how you answer that question, right? Agency head review and the effect of intervening regulations. But the statutory question of what legal consequences flow from how you answer that question is different from the antecedent question of whether or not it's a new agreement. And on that question, statute seems to me completely silent, and the case really boils down to whether that means the FLRA can give a whether agreement means agreement as understood at common law, in which case you lose, or whether agreement, because it's not defined in the statute, the FLRA can adopt an anti-common law understanding, in which case you win. That's how I understand the question. So
I think that's a correct way of understanding the question. And I would point you to some specific textual indications in the statute that actually the statute contemplates treating an agreement as being coterminous with a term. So specifically, I think the best example of that is in 7119 C5C, which says that the impasses panel's imposed settlements shall last, quote, during the term of the agreement. And so I do think that what we're dealing with here is a specific species.
Doesn't that beg the question of what the term is? If the parties contract for an A or B, whichever comes later term, that statutory language would give effect to that contract, correct? Whichever later comes.
So I think it raises the question of the term.
No. Well, stop. Hang on. I want to make sure we're clear and we're talking about the same thing here. Okay. So my hypothetical is what the parties have come to a meeting of minds on is that the duration of this, the defined term of our agreement is A or B, whichever comes later. You would agree then that the use of the word term there in C 719, sorry, did you say it's A, C, whatever the provision you're talking about.
Sorry, I didn't get the site. Could you just repeat the site? 7119.
Is it
C5C, I believe.
Okay, thank you.
My bad vision won't go back fast enough on all these numbers. So, the use of the word term there would be the term as defined by the parties in the contract, your collective bargaining agreement.
So
yes or no?
So I guess one clarifying question about that hypothetical is the A or B, whichever is later, is B another specific date or is it an event whose date can't be known?
Does that matter?
I think it actually might, and for the following reason. There's very strong practical incentives for parties to have fixed calendar date end dates for their terms. That's because under 7111F, There's a procedure, I believe, for challenging whether a specific union should be the exclusive representative for a bargaining unit, but there's a safe harbor provision. If you have an agreement in place with a specific fixed end date, that creates a calendar by which
There's
you can
nothing
then
that
seek
says,
to challenge.
I guess this is
So
all
I
the
guess-
same language. I see you're pointing to language, but I don't know why that's an issue, whether it's a specific event or a calendar date.
Well, I think
Either
because
way,
if it's a specific,
it's a concrete termination date that they have agreed to. Is there anything in contract law that says if the termination date of a contract is a concrete predefined event, that's a disfavored term for an agreement rather than a calendar date?
I don't think there's a principle of the common
Are you
law of
aware of
contract,
any
but I also
case?
don't think.
Are you aware of any case though, under the NLRA, under government contracts, under general contract law, that is said if you have an A or B, A calendar date, B event, whichever comes later, that the A calendar date is favored, even if it's a later one?
I'm not aware of a case in the general common law of contracts, Your Honor, but again,
So your
I
whole
don't think that's
argument then is that-
dispositive here at all.
Okay, so they just used the word term there, which we assume Congress is not throwing away sort of established, settled meanings of language in this.
Well, there's also a
particular
number
area.
of other structural, I'm sorry to speak over Your Honor.
No, go ahead.
There's a number of other structural textual indications in the statute as well, speaking to the importance of government-wide rules and the ability of our democratically accountable officials in Congress or the president to promulgate rules that will bind
No, I
federal
understand all of that,
employees.
but
So
it's
here,
the Congress itself has said, and that principle and those things turn upon, they don't kick in. This is another policy judgment that Congress made, is that principle is balanced against the importance of allowing people to adhere to the importance in labor law of allowing people to have the effect of what they've mutually negotiated between workers and employers. And so that's why the statute also says that if an agreement is in effect, those policies don't kick in. So I don't know how saying there's policies matter. There's policies both ways, and Congress has drawn the line on whether or not the changes kick in when an agreement is still in effect or not, which is why we talk about the term.
So
you have to
Your
agree
Honor,
with that, right?
the FLRA, ever since the beginning of this statute, has interpreted that time-limited grandfathering provision, quote unquote, narrowly, specifically because of the other important policy interests here, the rest of the CSRA, which delegates important policymaking to OPM and to others, the president's policymaking power, Congress's other statutes. These are all very important sources of authority. And for that reason, the FLRA has made clear there needs to be an express term that expires in order for new government-wide rules to go into effect in a timely manner.
It has to be a calendar date and not an event.
Well, a calendar date is by far the most common way of delineating terms
Well, I think that may be debatable given how common these continuous provisions are. But I mean, the new contract that the FLRA assumes kicks in here does not have a calendar date ending. It ends upon the conclusion of a new collective bargaining agreement. So you got the same issue either way, your same policy arguments either way. So either, you're not going to have one way or the other, you're not going to have a calendar date for the end of these continuance provisions.
Your Honor, we're not here to say that an agreement of indefinite duration is impossible under this statute. We think continuance clauses are a permissible type of agreement under this statute, but I think it's important. I think the authority would be well within its power under this statute to say, well, if the parties have said that the agreement runs until a date certain, and then if there's still ongoing negotiations and nothing left in place, then something new has happened. The parties have already agreed that those are the conditions under which a new term will come into effect, and the authority is free to interpret the statutory term agreement to be coterminous with those terms, in part because of the extreme importance of allowing Congress to regulate the conduct of federal employees rather than arbitrators in the impasses panel.
Sorry, Judge Katsas, did I step on a question you had? I'm sorry.
No, I was just on that point. As to calendar date or event, I was just going to say it's every one of these clauses that I've looked at seems to be of the general form, shall end on a date certain, which is a calendar, or the end of negotiations if a party has given timely notice, which is an event. So the heartland of what we're talking about is the contract term of the form, but the term of the contract is calendar event, calendar date, or completion of negotiations, whichever is later.
So, Your Honor, I think in that circumstance, I heard my colleague from the FLRA say that the guidance here would apply. The reason the parties chose that calendar date is because it has important significance. It is.
I'm sorry, I thought you said it would not apply. I thought you.
I'm sorry, I thought
repeatedly said if it said A or B, whichever comes later, then it wouldn't jump in until the later date.
I think I heard her say in response to Judge Katsas' specific hypothetical from the CDC that the guidance would apply, but in any event.
She was assuming that was not an A or B, whichever comes later.
Right. In our view, I don't think or would be dispositive on that question at all.
Correct,
the reason the parties chose a specific calendar date is because it has meaning for them and it has meaning for us. For them, it triggers the preclusion of certain decertification challenges, which is very important for them. If they were to lose that, I don't think they would be happy. Second, for us, it creates a date certain by which Congress and the president and OPM can create new rules through democratically legitimate means to govern our federal employees. That's what Congress wanted in this statute. And again, just pointing to, I'm sorry.
What is the difference between the hypothetical A or B, whichever is later formulation, and the CDC provision, which I read? And they seem to me substantively identical. I can give it to you again if you don't have it handy.
No, so I thought you said the specific language was if renegotiation is in process but not completed upon expiration of this agreement, that's just the A date. So I think that that specific language is talking about A definitely being an expiration. I think in our view, the party's view as to whether it's an expiration or not is metaphysical and not important under the statutory interpretation question presented here. That statutory interpretation question doesn't give the parties the power to indefinitely forestall implementation of new government-wide rules.
Sorry, hang on a sec. Sorry, I'm having a little trouble tracking this. I thought the authority's position was the guidance covers this actual Article 40, which I read, but does not cover the hypothetical A or B, whichever is later. And if that's true, there has to be some meaningful difference between the hypothetical formulation and this actual formulation. So I guess that's what I don't see it. Those two seem to me just a variation on the same question. But if you want to defend, and if you want to say there's no difference and the guidance covers both, I understand that position, but I thought you were defending the distinction.
No, Your Honor, I don't mean to be defending that distinction. We don't think there is. And more importantly, I don't think this guidance on its face.
Sorry, so Civil Appellate's position, to be clear, is that the guidance does cover the hypothetical A or B, whichever is later formulation.
That's correct, Your Honor. And that's because this is a matter of statutory interpretation regarding the boundaries of agreements and terms. And that's something the FLRA gets to have a say about. And so
how do you justify that? How do you square that with background contract principles?
So I think you had an earlier question about whether there was a meeting of the minds and an agreement here, and you might be going back to that. And so just to have it,
you take it either way. Judge Millett's formulation was that we're under the original expiration term of the original contract. My formulation was there's no second meeting of the minds to produce a second agreement. So you can take either one, but I haven't heard a great answer to either of those concerns.
Sure. The meeting of the minds I'll take first. It is common ground between everyone here that if you have an agreement, say it's a ground rules agreement about how negotiations will be conducted for a new term agreement, the provisions of the ground rules set the conditions upon which there will be execution of the new agreement. So it's just common ground that a provision of a prior agreement can set the conditions against which the parties act to execute a new agreement. That's the rule in that situation. That's also the rule in the case of rollover clauses, where again, the parties do nothing by a specific date, triggering a new agreement. And I'm sorry, Your Honor.
If and only if there's a new agreement, though, right?
Yes, Your Honor, exactly.
What's the new agreement? Why does a new agreement arise when the triggering event is one party unilaterally says, I don't like this contract anymore and I want to renegotiate it?
So the new agreement is the failure of both parties to then reach a new agreement during the bargaining period before the expiration of the prior term. That conduct read against the background rule established by the continuance provision is the execution. That's actually identical to the rollover circumstance where parties do nothing by a specific date, and that is their. I saw you trying to ask another question, Connor. I'm sorry.
Sorry, I keep interrupting you with my facial gesture.
No, please.
I mean, in the rollover context, the rule is the contract will renew if neither party makes an objection and neither party makes an objection. And I can understand an argument that if that's the way the contract works and the deadline is approaching and party A says to itself, I have no objection. Party B says to itself, I have no objection. You can sort of think of that as an agreement by conduct. And if you can sort of think of that as a second agreement, you can maybe think of the extended term as a second agreement rather than the first. I just don't see how that works with extension, where it's not both parties say the same thing, which is I'm fine with this continuing. It's one party says I don't like this, and then there is a failure to reach a second agreement. The
failure to reach a second.
Ongoing.
So the failure to reach a second agreement before the end of the prior term, Your Honor, really is the result of both parties' conduct. It is possible to negotiate a new agreement before expiration. And even if the other side doesn't want that to happen, it's possible to advance impasses to the impasses panel and get a resolution. These are not impossibilities. And so it really is the course of conduct of both parties that leads to the continuance term being triggered. And to go back to this.
So it's,
sorry, Your Honor.
So it's the second agreement arises because the parties agree to disagree.
I think that's right, Your Honor. But I also think that really is materially indistinguishable from the rollover context, where literally the parties do nothing. That could be because they decide they want to have a new rollover term. It could be because everyone just forgot. But we still have a rollover term. And under longstanding precedent for 30 years that no one has questioned, including petitioners here, that's a new agreement. And it's that course of conduct read against.
Yeah, which is consistent with hundreds of years of common law, which deems it a new agreement in the rollover context, but not a new agreement in the continuance context.
So just to drill down further on that specific point, as we point out on page 31 of our briefs, the rollover rule doesn't depend on the parties using magic words about renewal versus continuation or remain in force. Either way, even if the rollover clause says this agreement will remain in force instead of this agreement shall be renewed, the rollover term is effective. It's a new term. There was a prior expiration date.
Yes,
It
but
was
what
reached.
triggers rollover provisions is both parties independently concluding that I'm not going to ask for renegotiations. And I guess I'm just going to assume it's not that nobody's paying attention to these things. I think people pay attention to these things. So they make a conscious decision. I'm good with doing this again. And the other side, by not asking for negotiations, makes that same conclusion. All right. And when a continuance provision is triggered by very different, it's not inaction, it is actually by very vigorous action, negotiations in advance, as you said. They usually set different terms for what deadline you have to ask for this by before the designated A calendar date. And then you're in negotiations, and it's the FLRA itself says that these things are stopgap measures that don't have the confidence of either party when these things continue. It's just maintaining the status quo. And so that seems to me quite materially different between the two. I mean, you don't dispute the FLRA's description of these as stopgap measures in which neither party has full confidence because they're negotiating, or at least one of the parties doesn't. Maybe one wants to keep it, but at least one of them doesn't. And we also know that if there have been intervening changes in statutes or regulations, the new CBA is going to have to take account of those. So there's going to be some recognition, there's going to be some change, presumably, unless nothing has changed, at which point who cares, right? So that's very different. It's the entire premise for why you're in this temporary stopgap time period.
So you've described it as temporary, as we point out.
No,
brief,
the FLRA, to be clear, I'm quoting the FLRA, temporary stopgap. That's their term.
As you know,
in which the parties lack confidence. That's their term.
Sure. Well, for one, clearly the continuance term is finalized and has the confidence of the parties. Otherwise, it's not really an agreement, right? So it has force, and no one disputes that the continuance clause itself has force. In that sense, it does have the parties' confidence. They agreed to it at the very outset in the first agreement that led to the first term, and that in conjunction with the parties' mutual failure to reach a new agreement before the expiration date, that's the execution. Execution here really is a term of art. Everyone recognizes that when the impasses panel imposes a settlement that neither party asked for, neither party wants, both hate them, and maybe even they don't want to sign them, that's execution. No one disputes that. It's a statutory term of art that takes into account the special context here of the government's specialized needs as recognized under 7101B of the statute, and the need to interpret this statute consistent with an effective and efficient government. And that includes our ability to create and implement new government-wide rules. Yes, a continuous term is indefinite, but no, it's not.
Am I right that these continuance provisions have been in effect for decades before this policy was issued?
To my recollection, I've seen what I think are continuance provisions in quoted contracts from FLRA cases dating back to the early 90s.
Okay. And it's pretty, as just Judge Katsas said, pretty established in contract law generally.
But again, I'm sorry, Your Honor.
Okay. Thanks, Judge Round's question.
So, Mr. Reese, if you could just maybe state a little more clearly, going back to Judge Katsas's question earlier in this argument. So if we were to disagree with your view that this position is consistent with certain contract law principles, like what is the best argument that the government should prevail here? I mean, if we think that this reading is not consistent with sort of contracts 101 principles.
That the statute here is using the word agreement in a way that's different from contract 101 principles. So I take it actually as being undisputed among the parties that the FLRA would have the power to interpret the word agreement here to disallow a forever agreement, an indefinite agreement with no known end date, right? But of course, I think under contract 101 principles, parties would be free to agree to such an agreement. So I think we know that we're dealing with something here that is not just subject to the whim of the parties, in which the FLRA has no view as to what the boundaries of the agreement are. The Supreme Court in 1999 made clear that the statute's definition of agreement is ambiguous and circular, and that the FLRA has therefore been given power by Congress to fill in the gaps to best effectuate the policies of the statute. That's what the FLRA did here. It balanced the important interests in labor stability during the first express term of an agreement against the government's also very important interests in having federal employees' conduct controlled by democratically accountable officials. And it reached a common sense resolution that is consistent with its rollover cases that have been around for at least 30 years and that no party challenges here. And it's consistent with the text and the structure of this statute. The statute, again, contemplates that agreements are coterminous with terms, which I think is actually a little bit different than perhaps what the common law might allow for. The common law doesn't require, the chopping up an agreement into terms. It may or it may not, but here a term is an agreement. And the FLRA was well within its authority to say, if the parties go about specifying a specific end date in order to gain the benefits of, for example, displacing certification challenges for a period of time, then the parties should be bound by the idea that that really is meaningful for the parties outside of that context. It's the end of that term, regardless of whatever specific wordsmithing the parties might want to come up with in order to, forestall implementation of government-wide rules for an additional time period. There was an expiration date. That date was reached. That's the entire reason why the continuance clause is triggered. I think the FLRA was within its authority to recognize that something new really has happened when that first date is reached, because it's only by reaching that first date that the continuance clause was triggered in the first place. It's not as if nothing happened here. And I'm sorry, Your Honor.
If my colleagues have any more questions? Okay.
Thank you.
Thank you very much.
Thank you, Your Honor.
And we need, Ms. Bailey, I think you have 2 minutes of rebuttal, correct?
Yes. Thank you, Your Honor. I'd really like to make one simple point, which is if the parties want their contracts to end on the calendar date listed in the contract, they don't need to include a continuance provision. If they don't include a continuance provision, that calendar date will be the expiration of the agreement. I'd be glad to answer any other questions from the court. Otherwise, we'll rest on our briefs.
Questions? Okay. Thanks to everybody. The case is submitted.
Case number 20-5233, Campaign Legal Center versus United States Department of Justice, appellant, and case number 20-5234, Campaign Legal Center versus United States Department of Justice, appellant. Mr. Sinstack for the appellant, Ms. Oline for the appellee.
Thank you, Mr. Sinstack.
Thank you, Your Honor, and may it please the court. Jerry Sinstack appearing on behalf of the Department of Justice. Plaintiff in this case seeks drafts and embedded editorial comments on a letter that was sent by the Department of Justice to the Department of Commerce in December of 2017. Those drafts and the embedded comments within them are both pre-decisional and deliberative, and therefore squarely qualify as protected by the deliberative process privilege. They are pre-decisional, as the declarations submitted make clear, in the sense that they predate the final and official copy of the letter that was sent in December 2017. They are deliberative in that they reflect the give and take of the agency consultative process regarding what material should be included in the letter, what material should be excluded, comments and questions and analyses of the letter itself, and so forth. And therefore, they plainly fall within the deliberative process privilege. The district court concluded otherwise on the ground that they were not pre-decisional because they post-dated the decision to send a letter. That is incorrect. As I mentioned, the deliberative process here is the deliberative process that culminated in the final version of the letter that was sent, in the official version of the letter that was sent to the Department of Commerce in December of 2017.
Once the letter itself was finalized, though, events after that would not be protected.
I mean,
At least as relevant to,
I mean,
the only
as relevant-
relevant decision you flagged here is.
yeah, I mean, there could be, as Your Honor is well aware, I mean, there could be, if there were press inquiries, that might kick off a new deliberative process about how to respond
But
to
none of
those.
these documents are about that.
No, they're not. They are drafts of the final letter and an embedded commentary from Department of Justice staff on the letter.
On your view, what is the relevant decision to which these documents are pre-decisional?
It's the official version of the letter that was sent on December 2017. That final letter, that's the official letter from the agency embodying the decision.
And so I'm not sure anything turns on this, but I'm just trying to get straight in my mind what the decision is. Should we say that the Attorney General's decision that DOJ would send the letter was a final decision, but then there was a second final decision about what the letter would say? Or should we think of it as the Attorney General's direct decision to file something was not final because maybe he would have changed his mind?
Your Honor, I agree with you. I don't think anything turns on this. I think one could say there was a deliberative process that led to the decision to send a letter, as there often will be, but there was certainly a separate or an additional, or one could think of it as all the same deliberative process over what the letter should say, what its content should be. And that culminated in the final letter. So I do think it's true. There was really no final official action here until the letter went out. And so in theory, the Attorney General could have changed his mind at any time and not sent the letter. But if one were to conclude that's not, even if one were to conclude that the Attorney General had made up his mind and was not going to be convinced otherwise, there would still exist a deliberative process over what the contents of the letter should be and so forth and so on. And for that reason, these documents fall squarely within the deliberative process privilege.
Mr. Zach, how do we think about finality for these purposes? Like what a final decision is? I mean, the Supreme Court's recent decision in the Fish and Wildlife case from earlier this year, repeatedly suggests to the Bennett v. Speer test for finality. And I'm wondering whether you think that is the type of inquiry we should use in FOIA cases.
I mean, Your Honor, I hesitate to say that because I don't think it's the same test that might apply in an APA action. I mean, whether this letter has a real operative effect or creates legal rights, that's a separate issue. I don't know, but I think what this court has said in cases like the Dudman case, for example, which involved an official history by the Air Force, that this is the official position of the agency. This is its sort of culmination of its views or of the decision-making process. So I think in that sense, this letter was the official letter. I don't know that it would meet the test for Speer in terms of, at least it would in the sense of a culmination of the decision-making process. I'm not sure it would, for the purposes of whether it would be subject to APA review as a final agency action.
So you don't think those tests are coterminous?
I mean, I'm not, I don't think it, I guess the answer to that question, I mean, I'm hesitant to answer because I don't know what the department's official position would be on that. I do think when you're talking about drafts of a document, whether that, when you have the final official document, that's relevant for purposes of FOIA, whether that document would in and of itself be final agency action for other purposes. I don't think that's necessarily the case.
Couldn't possibly be final agency action under the APA. It's just
exactly
DOJ's advice to Commerce. The final agency action is Commerce passing a reg or not, adding the are you a lawful resident or are you a citizen or not to the census?
Exactly. Yeah. So I don't think it would qualify in that sense, but I don't think that's the sense this court has used the term.
It is interesting that the Supreme Court repeatedly cites to the Bennett test in discussing that. So
Yes, and I think
And references legally operative effect.
right, but I think one thing that's clear here, whatever test one applies to the final letter, certainly the drafts of that letter weren't documents that the agency treated as the final word or the official word. These are drafts circulated by staff of the department and comments and so forth from those staff members, and certainly nothing. Whatever the final letter might qualify, certainly these drafts weren't treated by the agency as final and not subject to further change.
Struggling with another Supreme Court decision in the Commerce Department case that said the decision to claim that this question would promote the Enforcement of Voting Rights Act was contrived, in the Supreme Court's words, a contrived decision. If an agency head is just, I'm making something up, it's completely false, but I'm going to say it. I'm going to go out to reporters and I'm going to lie through my teeth because I don't want to tell them the real reason. Draft me up some lies. Are you aware of any case in the common law that applied the deliberative process privilege to that time, where it's not, you're not really making a decision? There's no decision to be made. If the guy's already said, I'm exaggerating here, of course. The Supreme Court was softer in his language, but for hypothetical reasons. Agency head says, I'm going to go out and lie just for kicks. I'm going to lie. I'm not making any decision here. Give me some lies. But that's the deliberative process that's protected by the common law privilege?
Well, Your Honor, I'm not aware of cases either way. I'm not aware of a case court saying it is or isn't. I know I guess obviously, as Your Honor knows, that wasn't the circumstances here. And I think it would depend, when you look at the declarations and you look at who was involved in the drafting process, there's no reason to think that the individual staff members were anything but sincere in their efforts to deliberate about this letter, which could include critical comments about the letter and its purpose. So from their perspective,
I'm just asking you though, I'm trying to reconcile the Supreme Court saying that this was a contrived decision with the coverage of the deliberative process.
Well, first of all,
if I were to tell you that there were cases kind of going different ways, some would say that's just not covered in common law by the deliberative process privilege. Are we supposed to apply those?
No, Your Honor, because I think, as this court has said in cases like National Security Archive, what the point of the privilege is to protect staff, for example, or individuals who are participating in the consultative process to be able to provide their candid advice and so forth. So
was this letter providing advice to the Attorney General? Or was it just...
Yeah, the Attorney General, I think one way of looking at
how to articulate the Attorney General's conclusively determined position.
One way to look at it is that Attorney General, even assuming he made the final decision, then he delegated to staff the equally important considerations about which arguments to make in support of that decision and what justifications to proffer and to get advice on how to do it and so forth.
I think the substance that it was going to be to help enforce the Voting Rights Act, that was already predetermined as well. And so this...
But it
feels more like how are we going to message that? The decision's been made. How are we going to message it?
Well, but I think that is a common feature. If we just, to use the Reporters Committee case, for example, James Comey decides to send a letter to the editor and decides to defend the policies of the FBI. There still remains a deliberative process, exactly how to go about doing that and what the content of those communications. And no one, I don't.
The deliberative process there was do we stick with our policy, our old policy that's under fire? If we want to keep it, how are we going? Anything like that?
Well, I think I don't want to fight the comment too hard. I think the Supreme Court actually said there was nothing inappropriate about any of the individual steps in the process. And so if we're talking about deliberations among staff of DOJ about what goes into this letter, I don't think there's any reason to assume the Supreme Court thought that the staff members were engaged in anything other than a sincere effort to provide their candid comments.
No, it could be a sense. So one I made it extreme to make sure we're in hypothetical land. We're really not talking about that,
Right.
which is obviously the case in front of, just to understand the contours of the deliberative process.
And I think,
Privilege, but if what they're really not doing, they're really not advising someone. Decision's been made. Here's how you do it. Voting rights, but they are, sincerely trying to figure out how best to articulate that. I didn't see that in your affidavits. It just seemed to sort of say pre-decisional. This was pre-decisional. It was draft. It counts, as opposed to explaining for us, what kind of deliberations, substantive policy deliberations still were to be made. I can imagine all kinds of them, but it's not my job to imagine them because I could be wrong. They're supposed to be in the declarations, but they're not.
well, I guess I would point, for example, the declarations for JA 406 to 410, for example, in which there are explanations of,
Hang on, let me catch up with you.
Sure. I'll pull it myself.
All it says is we're writing a draft. We talked
I
about
think
drafts.
it says, we are offering analyses, suggested edits, contemplating strategies.
It's just
tracking-
boilerplate language for any draft. I bet you that shows up in lots of affidavits.
I think there are.
There's nothing particularized helping us to understand what was still being deliberated, what the concerns were.
Well, certainly I think it is contained.
Boilerplate.
Sure, and I can point to more examples, but I think what is being debated, as explained here, is what is the content of this letter? How can we make it more persuasive or stronger? Or this is something that's going to be viewed by others, and you see, it notes that it includes, and I don't have the exact date for this, but analysis by staff of the letter, comments asking for clarification, comments raising questions, and so forth. And I think that clearly indicates that they're still debating what this letter should say. Red line, proposed edits. What are the justifications?
Yeah, I get that they were drafts, right? I get all it does is say these were drafts, right? Drafts have red lines, edits, comment bubbles, nits, those types of things. But there's nothing here. Again, I can imagine a lot in my head as to what people would want to be careful about in articulating something like this for all kinds of strategic reasons. But I'm imagining that in my head because I didn't see anything in your affidavits that told me, what kind of concerns. You could say safely without revealing content, what kind of concerns were being balanced or addressed.
I mean, perhaps they're not as clear as they could be, but I would.
No, they're not beyond boilerplate. It's not clear. There's nothing there that wouldn't show up in every single affidavit for a draft something or other. If it would, and maybe this would be better on rebuttal, if there are particular parts of any of these affidavits, particularly in the OIP one, that you can point me to that help me understand in this scenario where a final decision had been made to ask for the question and to do for it on the grounds of Voting Rights Act enforcement. If you can point to me, take those as a given. Mm-hmm. Where there's something here that doesn't show up in this particularized to these cases, doesn't show up in every other affidavit like this, every other draft document, FOIA affidavit. That would be really helpful. But you could do that on rebuttal.
Okay, I can do that on the break.
Time now, yeah.
But I do think the policy, the justifications and contents of a policy announcement are as important as they're integral to the policy itself. So a debate about what should be included and what shouldn't be do implicate policy concerns. And I'm happy to answer any further questions.
My colleagues don't have questions. I have a particularized couple, but I don't want to keep on JA 608 to start. This is the Civil Rights Division's Vaughn Index.
Mm-hmm. Yes.
So the dates go very sweeping here, December to December 2017. And we all know that at some point, anything after December 12th for sure, but certainly sometime during the day on December 12th, things stopped being pre-decisional because that's when the letter was issued. And it describes in the end of that first paragraph there that a few emails discuss the logistics of transmitting the Gary letter by fax and email. Can we agree that once you've got final sign off and someone's just figuring out whether to do fax or email, that's not pre-decisional part of the drafting process? Or if not, point me to an affidavit statement that explains how on earth that is part of the deliberative process.
Yeah, I mean, if all we're talking about is the logistics of transmitting it, unless there's some, I suspect I'm not going to fight you on that point.
Okay.
And that may have been something that was released, because these are just suggesting that parts of the emails, but to the extent it wasn't.
Well, this is just right. I don't know if they were withheld though. That would be, it's not clear at all to me because
Yeah,
we don't have the unredacted
to be clear, what we're
documents that this was not redacted. So you're not saying that.
no, to be clear, the thing we're defending here are the drafts of the letter, the comments included, the cover emails, which also included comments, of a piece.
When they do that, but you're not defending things that are just talking about the logistics, the timing, or which mechanism to use. Are we certain? And if that's
I'm
true,
not certain. I'm not certain. I would assume we're not, but if it's simply just send it by fax or not. I mean, I know I was reading the record and we're going to fax this was, I think, one of the emails, that was disclosed. So I don't, but I would assume that not. But any event, I apologize for that. But the focus here is on.
It shows up numerous times here. It shows up again on JA 615.
Well, and we did disclose a number of things that are, only partially redacted, for example. So I can check but the focus of the appeal is not on those.
Yeah. Okay. I was concerned about that. So, okay. There are other ones that emails that seem to be talking about timing, and then there's a block out, and it's not at all clear to me, given these Vaughn index descriptions, whether what followed that was talking about timing, fax, email, or whether that was talking about a whole new deliberative process, something that would fall within the deliberative process here. So it seems to me there's a lot of confusion to me, at least, between these Vaughn descriptions and
in the Vaughn, indices covered a number of documents, but many of which were released, some of which were released in response to the district court's opinion in this case. And I did, just to, go back to an earlier question. I mean, I think we see in the following paragraph, these emails discuss edits, comments, and revisions. The emails also discuss draft versions, formulation of additional questions to elicit relevant information, and numerous edits and changes. These emails contain questions and responses.
Yeah, and I'm not disputing that.
So,
It's the weirdness of that other line in there, right? Everything else is describing stuff you're withholding. It would seem weird to have a sentence in there that describes something that you're releasing.
Yeah, I agree with that, but but I'm raising that paragraph in part to note, to your response to your Honor's questions about, descriptions of what's contained that, in these drafts and comments and edits.
Well, yeah, but there's nothing particularized there, right? I think we can all agree that every time you claim the deliberative process for a document, you're going to say for a drafting process of a document, because it was drafts, it was comments, it was questions, it was transmissions. But this one is an unusual case where
I guess
the big decision's already been made, as well as at least some level of content decision. It'll be the Voting Rights Act. And so
but as
helping courts and the public understand, because the Vaughn Index serves a public accountability process to help us understand what the type of decisions making that was left to be done is. The policy decision making.
Yeah, and I guess what I would say the policy is regarding the specific contents and justifications and so forth that appear in the final letter.
Thank you very much.
Thank you, Your Honor.
Celine?
Good morning, Your Honors. Elizabeth O'Lean for the Appellee Campaign Legal Center. The court should uphold the district court's findings that the drafts and emails at issue in this unusual case are not pre-decisional and not privileged for 3 reasons. First, withholding the documents would undermine the aim of FOIA to open agency action to the light of public scrutiny and provide a check against corruption, because the Gary letter sets forth a contrived and pretextual justification for an already made decision. Second, the documents are a functionally final decision in draft form and thus not pre-decisional. And third, disclosure will not harm or chill the internal agency process because the Department of Justice was not engaged in policymaking when it drafted the Gary letter.
If the Attorney General had said, I am not sending a letter. I am not requesting a citizenship question. This is hypothetical, obviously. I think it would damage our enforcement of the Voting Rights Act or some other statute. We are not doing it. That is my final decision. And it's my final decision. I'm making it because it's going to harm civil rights enforcement. Go draft that letter to this team. Would drafts of that letter also be released?
Yes, those drafts would also not be pre-decisional, because in your example where the Attorney General said to write a letter saying that we will not support this rationale is essentially the same as the facts that we have here. What happened in this
How do you distinguish that from Reporters Committee, right? Dr. Comey said, I'm going to do an editorial, let's get it written. And it's do an editorial defending our practice. Let's get it written.
Yes, so the distinguishing point between the reporter's case and this case, as you wrote, Judge Millett, there is no allegation that Director Comey was providing any sort of direction or explaining the basis for a final decision to his subordinate in these emails.
Wait, that was sort of in the sentences and the details, but there was no question that he had made clear there's going to be an editorial and it's going to defend our policy. That's a direction to them. They didn't have discretion to defend, to make that what the substance of it was going to be. It seems to me identical to my hypothetical.
So it is different, Your Honor. And the reason that it's different is in this case, not only did the Attorney General direct his subordinates to write the Gary letter, he also directed them the rationale to provide. So unlike Director Comey, he did provide direction explaining the basis for the final decision. And we know that.
What about when the Solicitor General authorizes an appeal? And that process will identify what issues can be raised on appeal, what cannot be raised on appeal, what arguments are made. And the Solicitor General signs off and says appeal, which means to the litigating appellate staff, go write the brief consistent with the directions in the memos. So does that mean every draft of a Justice Department brief authorized by the Solicitor General is also post-decisional?
No, Your Honor. And I think a key difference here is that the Attorney General did direct the staff to use a specific rationale, but he also was not engaged in policy making and agency-oriented policy judgment when he made that determination. At the very beginning of this matter, to take a slight step back, the Secretary Ross had asked his staff to reach out to the Department of Justice and other agencies to find someone willing to support his position. The Department of Justice did engage in a deliberative process where they considered the voting rights rationale, and the staff determined that that was not something that they could support. It then went back to Secretary Ross, who said, I want this to happen. There was a call scheduled between Secretary Ross and Attorney General Sessions. Just prior to that call, the record reflects at 190 that there was an email between the Department of Justice staff and the Department of Commerce staff, and the Department of Justice wrote, it sounds like we can do whatever you need us to do. The AG is eager to assist. So that email, I'm sorry, Your Honor.
Ms. Helene, why does any of this matter to whether there's actual policy making? I mean, I understand your position is that something unsavory happened here because political appointees disagreed with the staff and made a decision about what should happen here. But so, I mean, in a context in which you think that the decision making is not appropriate or is somehow fudging, I mean, are you suggesting that you get a kind of super FOIA in those cases? You know, you get kind of extra FOIA even when they are actually deliberating and going through a process just because the policy is ultimately not one that is one that you agree with? I guess I'm not really sure what all of this is related to with respect to whether something is deliberative. I mean, people are deliberating, maybe not in the way that you think is appropriate, but I'm not sure how that takes it out of the deliberative and pre-decisional box.
Yes, Your Honor. So to answer your first question, no, we are not advocating for a super FOIA, and I don't think that any sort of super FOIA is necessary here. The emails and documents are properly disclosed under the law as it exists today. In order for something to be pre-decisional, which it was the only prong that the district court got to, it would be a document that was prepared to assist an agency decision maker in arriving at his decision rather than to support a decision already made. And here, based on the facts, we know, particularly as evidenced by the email from the Department of Justice staff to the Department of Commerce staff, that the decision for the content of the letter was already decided. There was already a decision from the highest level of the Department of Justice that a request would be made to the Census Bureau to add the citizenship question, and that the rationale for that would be enforcement of the Voting Rights Act. And
Aline, isn't that, as Judge Millett was also discussing with her example of the Solicitor General, I mean, isn't that a very common feature of government decision making, where a senior official decides, makes a decision about what's going to happen, maybe the primary arguments that are going to be made, but there's still a lot to be worked out in the details.
Your Honor, this case is very different from, and it is very unusual, and it is not like any of the other cases in the existing precedent where that could be the case. The facts that we have here and the record that we have here includes a decision from the Supreme Court that was written by Chief Justice Roberts, in which he characterized the Voting Rights Act rationale as pretextual. So it was not, in fact, the actual reason for the decision. Any discussion that would have been occurring in the drafting of the Gary letter would not have been about an agency policy decision.
I didn't see this type of argument in your brief. I saw you arguing that the decision had already been made and the rationale had already been given. This was all post-decisional, and they weren't claiming that this was a messaging case. I didn't see you arguing that instead there's a question about whether the deliberative process privilege applies at all in the case of, for example, hypothetically, a false or fraudulent agency pronouncement. I just didn't see that. I didn't see any cases or discussion about the common law history of the deliberative process privilege. So it sounds now like you're trying to say this is sort of unique for precisely those reasons.
So Your Honor, on page 8 of our brief, we did address this briefly, and we said that the Gary letter itself does not reflect a typical agency process for formulating a process as the department.
It may not be typical because things aren't always typical. Editorial drafting isn't always typical either. I didn't see you arguing that it's a matter of the common law deliberative process privilege that Exemption 5 brings into the FOIA. It just doesn't apply. You take it as applying, but you just say it's not. The terms aren't satisfied here. This is post-decisional. Come on, this is post-decisional, and there's nothing really deliberative going on.
Yes, Your Honor. Yes. And
that's a different argument.
Yes, Your Honor.
I'll give you a hypothetical, which is the government is deciding whether or not to take an appeal involving the Department of Commerce. And a lot of the line lawyers in DOJ are recommending against appeal because they think the government's position is very difficult. Secretary of Commerce calls the Attorney General and says, "This is really important to us. Please help me out." Attorney General says, "I understand, I'll do it." the Attorney General tells the Solicitor General, this is really important, you need to do this. The Solicitor General authorizes the appeal and gives general direction. We're going to take the following position. It's one sentence. On that hypo, would the draft DOJ briefs implementing that decision be protected?
The draft DOJ briefs would be protected.
Okay, how is that different from this case?
So that is different from this case because in the hypothetical that you provided, there would be latitude amongst the DOJ staff to craft the arguments. And the difference here is that there was not, I think the situation—
You don't think there's latitude from the Attorney General says, we're going to send a letter taking the position that this question would help voting rights enforcement. And the end product, which is a 3-page letter that reads like a substantive, very substantive legal analysis. It could be like the summary of a brief, and some lawyer in DOJ decided that Reyes versus City of Farmers Branch was a good case to cite for some proposition about citizen voting age population. You don't think there are legal judgments in going from the direction of the Attorney General to this final product?
No, Your Honor. I'm sorry. Yes, but the distinguishing factor in this case is that the content of the Gary letter was not the actual reason, the actual policy reason for the request for the citizenship. And it was not specifically called out in our brief, but it is in the record at page 376. There is a memorandum from the House of Representatives who had done an investigation, and their investigation through the interviews revealed to them that the actual purpose of this request had to do with redistricting and an attempt to entrench a political party in power. So the Gary letter, as the Supreme Court found, was simply a pretext. It was not describing an actual policy decision of the department. And this is further demonstrated by the fact that after the Census Bureau received the Gary letter, they reached out to the department to confer further. Like in Fish and Wildlife, there was an expectation that the draft would be provided to EPA and they could discuss it back and forth before reaching a final biological opinion. In this case, the Census Bureau reached out to the department, and the department, as the Supreme Court found, showed no interest in further discussing this matter.
Then you are advocating for a different standard, right? Because if Judge Katsas's hypothetical would be covered by the privilege, but this letter is not, then you are asking for a different standard in the context where some external party thinks that the decision-making is pretextual or inappropriate, right? You're asking for a different standard based on the substance of how the decision was made. Because you're saying in the one context where it's a brief, like there's some kind of honest, decision-making process and that's covered. But if it's a pretextual decision-making process, or if someone thinks it's a pretextual decision-making process, that is not protected by the privilege. I mean, that's the distinction you're drawing, isn't it?
Yes, and I would qualify that by saying that the purpose of the deliberative process privilege is to protect the agency decision-making process rather than to protect decisions that are already made. And
what if the State Department or the CIA, for national security reasons, said we need to issue a letter that says the reason we are drawing down our embassy staff in country X is because of COVID concerns inside that embassy. And in fact, the reasons are much more complicated, and it is all a ruse to cover up the fact that there is, say, an impending military action by the United States or an ally. So it's an deliberately, sorry to use that word, pretextual explanation is going to be given by a national security agency or a foreign relations agency, because that's the best way to protect the interests of the United States of America. And they say, go draft that. Go drafts of that because they're pretextual, openly within the agency known to be pretextual reasons. Would they be available?
Your Honor, I'm sorry.
No, would they be protected or not? You're saying they would not be protected because they're pretextual.
So I have to admit that I am not familiar with national security law.
You don't have to be. This is FOIA law. So just FOIA. With the deliberative process privilege under FOIA, your exception that you want to make for pretextual agency decision makings, would that apply then to a press statement issued by the national security or foreign relations agency that was pretextual?
Correct, Your Honor. So assuming that there is not some other statute of which I'm not familiar with it.
We're assuming there's no other exemption applicable. This is all we got, one way or the other.
Yes. So I think then the key place to focus is the three aims of the deliberative process privilege. And I think in your example and in this example, the three aims are instructive. And I think that you would reach the same outcome because the purpose of FOIA is to shed
same outcomes as you're asking for here. So we would release the drafts of those drafts of that press release or press statement.
Right. And so the three
even
points,
though those drafts would be saying things about here's the real reason we're doing it, but we can't say that. So let's try saying it this way. And then someone says, well, we can't say it that way because that's going to spill the beans on some other operation we have going somewhere else in the world. So let's rewrite it this way. All those things are going to come out because the enterprise, the exercise itself was pretextual.
Again, Your Honor, I think it would come down to, in your hypothetical, a question of whether the State Department was actually engaged in policymaking. And in your example, it sounds like there were real policy considerations and concerns. What would drive the analysis would be whether there was any danger that the subordinates would feel inhibited by their opinions. And in this case, the internal discussions, there would not be because they had agreed up front, long before drafting started, months before drafting started, that they agreed to the decision and the voting rights rationale. There would be no danger of a premature disclosure of a policy that had not been finalized, because in this case, again, the decision was made up front, the rationale was decided up front. And there would also be no danger of confusing the public about the reasons or rationales in this case. Again,
so Ms. Oline, your position then as a legal matter is that it's a document is only deliberative and pre-decisional, not just because it's deliberative and pre-decisional, but if it's deliberative and pre-decisional and serves the policy purposes of that protection. So judges then have to determine not only whether something is in fact deliberative and pre-decisional, but also whether it meets the policy purposes behind that protection.
I don't think that it necessarily matters as much whether the document meets the policy purposes, and maybe I'm misunderstanding your question, as much as whether it reveals an agency's or an official's mode of formulating or exercising policy judgment. That was not the case here. Enforcement of the Voting Rights Act was not a policy of the Department of Justice. It was, as the Supreme Court found, a pretextual reason for a different policy, which was redistricting, and that was what was not described in the Gary letter. I think it would be a very different circumstance if the Gary letter described the actual policy reason, which was the redistricting, because it describes a pretextual reason that we now understand was not the reason for the letter. I think that's the difference.
I don't understand the relevance of that, because Supreme Court said that the Department of Commerce's decision, while not itself unreasonable, was pretextual because the DOJ voting rights position didn't reflect the actual reasons why the Department of Commerce wanted to add the citizenship question. So, okay, maybe the Department of Commerce wasn't being as candid as it could, but I don't understand, why does that tend to suggest that within DOJ, when the Attorney General says, we are going to take the position that this question would be helpful for voting rights enforcement, why would that tend to show that the DOJ lawyers who were left to operationalize that decision were doing anything other than what DOJ lawyers do every time they operationalize the appeal decision by working on the brief?
Correct, Your Honor. So I think the answer to your question goes back to the first question that you asked of Mr. Sindak, which is, what is the operative decision here? And I disagree that the operative, or my client disagrees that the operative decision is the decision to write the letter. The operative decision is the Attorney General's decision to make the request and to use this rationale. So at that point, it has removed the discretion from the staff. And so, so that's the difference. I'm not sure I quite answered your question.
That's not, I mean, that's an answer to my question, but it doesn't distinguish every single DOJ appeal where the SG does exactly the same thing on the front end.
Again, Your Honor, I would submit that the key difference here is the fact that the decision and the rationale were not the actual policy of the Department of Justice. In the briefing that you've described, you know, in your hypothetical, ostensibly, the arguments that they are putting forward to the court would be the Department of Justice's actual
the voting rights angle was the actual position of the Department of Justice.
The record reflects that it was a position that the department did not support. They had actually considered the staff.
But it was the decision of the Attorney General.
That is correct. That is correct, Your Honor.
And then the line attorneys were charged with operationalizing it.
That is also correct, Your Honor. But the distinction is the decision point, because if the decision is the Attorney General's decision to give this order to his staff, then the Gary letter is a post-decisional document, and they had no discretion. Whereas if, as the department argues, the Gary letter is the decision and the contents of it are the decision, then it wouldn't be. But it's our position, as the district court found, that the operative decision is the Attorney General's decision. So the Gary letter is necessarily post-decisional.
Colleagues, have any further questions? Thank you very much, Ms. Aline. We'll give Mr. Sindak 2 minutes.
Thank you, Your Honor. I think the only thing I have really is a response primarily to Your Honor's earlier questions about drafts. I have a number
Particularized to this case.
I have a number of pages to cite. I think they're of a piece with what I had quoted earlier in terms of, on page 456 of the JA, drafts were circulated for additional review and input.
Let me catch up.
Oh, sorry about that.
Sorry. Then we do beat your time up by turning pages. Okay.
This is the middle of paragraph 30 or the end of it. They contain questions to list relevant information, comment bubbles, edits regarding the final contents of the letter for determining the final contents. The next page, 457, they talk about there being opinions, comments, edits, and recommendations. There's similar wording. I know Your Honor is going to say that was typical of other.
If you can represent to me that that's atypical language as opposed to.
Well, I think what's typical in
language in every deliberative process affidavit, I'd love to hear it.
Well, I think they are similar, in fact, very similar to declarations submitted. For example, in Machado Amadis, I think if I'm pronouncing it correctly, quoted language very similar to this as being satisfactory. I think the implication here is that, we have the final letter. We know the arguments that were made in that letter, and these are comments and suggestions and edits and so forth, questions about what those justifications should be and so forth. And that implicates policy because, of course,
the affidavits in Machado, I'm saying that right, had a lot more detail about the specific process.
I guess
they were called, but there's a specific process and they named the process and how it all worked internally. And that's not here at all. This could be any FOIA affidavit for any agency doing it.
Well, I guess, when an agency is settling on its official position and publishing its reasons for that position, for example, of course, I think
but here
most of the drafts and deliberations going into that.
It's going to look the same, but here what you had to do was sort of say, look, even when a decision's been made that we're going to do this and a rationale has been given, it's still important within the government. Important decisions still have to be made.
Regarding what the justifications are, what the support for. So, what the support for that position
They've
is.
already told you the justification, the Voting Rights Act. So,
what specific arguments, what material should be included, what material should be excluded, what facts, what cases should be cited, how long the letter should be, how it should be phrased, and so forth.
You're a better talking affidavit than I got here.
Well, I apologize that wasn't made clearer. I think that's the implication of these comments. And we have a number of cases, for example, like Kerkorian, where there were version drafts of a letter, and those were considered deliberative.
I'm just saying, we know from Machado that agencies are actually fully capable of giving us more granular agency-specific explanations than what we had here.
I appreciate that, Your Honor.
Any other questions for my colleagues? Right.
You are content to have us decide both deliberation and foreseeable harm on the current affidavits? You didn't have the benefit of Machado when the affidavits were written.
Yes, Your Honor. I would point out the unforeseeable harm issue hasn't been briefed by or decided by the district court or briefed by the parties.
Hasn't even been raised, I don't think.
Or hasn't been raised by the plaintiffs. But yeah, I think the deliberative, we are comfortable with the deliberative. that was briefed. We did brief that, and the declarations are.
Great, thank you. Thanks to all. The case is submitted.
Thank you.
This honorable court is now adjourned until Friday, September 17th at 9:30 a.m.